I'm actually trying to reach him right now. I've texted him
Oh,
and
here
called.
we go.
Here he is.
Yes,
Yes, I took your 15 minutes seriously.
that's okay. I figured you might have gone to get a cup of coffee or something. It's perfectly fine.
Thank you.
Okay. So I think Mr. Powers discussed perhaps taking a record. Is that kind of where you're at too, Mr. Hiller?
Yes, ma'am.
Okay. All right. Well, then we will go on the record in D1 FM 21-435, Catherine Lee Walker versus Toby Jean Stoops. I would ask those present for their appearances for our record, beginning with you, Mr. Powers.
Yes, William Powers appearing for Catherine Walker, who I believe was the petitioner in this action.
Okay. And Mr. Hiller.
Yes, I'm Michael Hiller, appearing for Toby Jean Stoops, who is the respondent.
All right. And I guess just for our record, Mr. Powers, is Miss Walker there with you?
Yes, on the video recording, I guess that would be my left shoulder as you look at it, but it's actually my right shoulder. I'm also being assisted today by my paralegal, Amy Olson.
Okay. And Mr. Hiller, you've got your paralegal here with us in the Zoom, correct?
That's right. And although my client did get the link, I don't see him.
Okay. Do we need him to proceed? I wouldn't imagine.
Is this a motion to enter based on a mediated settlement agreement? I'm
Right.
happy to wait for Mr. Stoops for a reasonable amount of time, or we could go forward. I don't think it's a lengthy hearing.
Yeah, I agree with Mr. Powers that it's not a lengthy hearing, and it wasn't clear that he was coming anyway. So since it's already 9:20, and unless my paralegals heard from him, I have not. So I don't think there's a reason. Marnie, have you heard from him?
No, I have not.
Okay, then we're fine to proceed.
Okay. Is there someone who can share screen with respect to the couple of red lines we've got?
Yes, ma'am. I will, if you're ready to proceed, I'll give you a quick little rundown.
Your Honor, if I may, so Mr. Powers, they submitted an older red line of ours, and I just want to make sure because we have a red line as well that's newer.
Well, whichever one is the most updated. I mean, what
Yes.
my process typically would be.
We're going to share his most updated version.
Okay. And then we can take them each where you let me know, Mr. Powers, what your position on it is, and then I'll hear from you, Mr. Hiller, or vice versa.
All right.
It's better to me. Okay.
Thank you.
Real quick piece of background, won't take 5 minutes. This case has been pending since 2021. And we mediated an agreement in 23 on January, mediation was on June the 29th, 2023, and we finally called it into a couple of issues that are in dispute.
Okay.
By the way, is this the version we sent by word?
No, this is Mr. Hiller's version.
Okay.
Yep, that's fine.
All right.
Because
The first dispute
These two, I think, are agreed to. These, I think, are agreed to.
Looks like ours.
they've agreed to these. We've agreed to that, right? What are you telling me about this?
This was language we put in, and I don't think it is disputed.
Okay. The red line language that we're sharing here on 4 and 5, we do not believe is disputed language.
okay, are we mean 4 and 6? Mr. Hiller, can you see that?
4 and 6.
I can. Yes, the 4 And 6, we didn't have any issue on the last.
Okay, Ms.
Yes.
Olson, if you'll accept those revisions on those two. Okay.
This number 7 is the first dispute between us, and it has to do with electronic devices. At some point, without an agreement between the parties, Mr. Stoops gave the children laptops and
Your Honor, I'm going to object to anything that's not, first
Okay.
of all,
Well, first of all, this is not evidence, right?
I understand.
We're arguing.
I understand.
So there's that. But
Okay.
I just want to hear what the dispute is about.
Fair enough.
So, Mr. Powers, if you'll go ahead.
yes, the dispute is about whether or not Ms. Walker, who is the primary parent in this case, can manage the children's electronic devices by having access to passwords and putting appropriate parental controls on them. Given that the phones were purchased, these electronics were purchased by Mr. Stoops, she doesn't have any access to them and would share with the court she gets pushback if she tries to exercise any control over them, as the children tell her they're not her phones, they're their dad's phones, and that's why it's included. Mr. Hiller will tell you that this language was not included in the mediated settlement agreement, and I would have to stipulate that that is true. However, we're asking that it be included, and we think it's within your power to do what's in the best interest of the children, whether it's in the mediated settlement agreement or not.
Okay. Mr. Hiller?
Yes, Your Honor. On that, you can hear me okay?
Yes.
So the good news is, and I've known Mr. Powers long enough and know his reputation, even though I've only been in Austin like 6 years, that he's going to tell you the truth about that it's not in the MSA. And at the same time, case law is very clear that Your Honor cannot add things. I mean, there may be slight things you can do for clarification. I think that we're here on language, but this is more than language. This is something, I've heard something from my client about where this came from, but this isn't clarification. This is a whole new clause, and it involves having her passwords and all kinds of things that seems like extreme control to me. But even if it were something else, if it's distinct and new and different and is now being added to the decree, I don't think case law allows you to do that. It's pretty clear there. It's a very narrow, as I'm sure Your Honor knows, there's a very narrow window for you to make changes or to reject an entire MSA, and that involves family violence and intimidation. And so because of it, and so my client doesn't agree to this, we don't agree to it, and we don't want it there, and I don't think you have the authority to put it there. And even if you did, there would need to be testimony for something like this, because I'm sure my client has a different view of how this even came about. So I don't think it can or should be in there, Your Honor.
All right. So unfortunately, Mr. Powers, I've looked at the MSA. I don't think I can add this provision.
Understood, Your Honor.
So I think it has to come out.
We'll delete it.
I mean, of course, I'd encourage the parties to try and work out this issue, because it's going to be a doozy if it continues. So
Right.
I try and I guess there's no parenting facilitator agreed to a parenting coach or anything like that in this case that I see.
That is,
Well,
Your
I'm
Honor.
sorry. Go ahead. Go ahead, Bill.
I'm just confirming what the court's
Okay.
assumption was.
And who did you mediate with?
Boy, I have no.
Oh, yeah. It was a 12-hour mediation.
That's one idea is to kind of, see if the parties will go back and help a mediator help them decide on.
It was with Mr. Bose, Charlie Bose.
Oh,
Yes, that's
okay.
correct. I just knew it was long.
Well, that's my idea, but all it is an idea. So
Right.
take with it what you'd like.
Yes.
All right. Okay, so where to next, Mr. Powers?
I think on P3, item E, we don't believe this is disputed, this whichever is greater.
Oh, I didn't know we had an issue there.
So it's okay to accept those changes?
Yeah.
Mr. Powers?
I
Okay.
mean, again, I don't think it's new. If it's something from before, Mr. Powers, I'll try not to call you Bill in the court. If it's something, as long as it's not new, I don't know what it is. Something about this is not something new, right, Mr. Powers?
It is not.
No, we don't have any. There were only two issues in dispute,
Okay.
and that isn't one of them.
Got it. Those are just those little pesky small ones that are hiding from you in the review.
Right, probably.
Okay.
All right. Let's get to the disputed issue. So this is language related to an asset that was divided 50-50, the assets in Ms. Walker's name, and on R15 here, the first part in blue was a revision requested by Mr. Stoops through Mr. Hiller. We've highlighted that revision, which was requested back in May of last year, and that was their first stab at revising this award. And then the language below that, and by the way, I don't know that language was in the mediated settlement agreement, but we agreed to it.
Okay.
The language, Catherine Lee Walker shall no later than June 30th, 2025, etc., in keeping with the very astute language that Mr. Hiller was sharing with the court. This is entirely new, and it's not in the mediated settlement agreement. And it requires a lot of time and effort on the part of Ms. Walker to provide financial things which she may or may not have access to, which may or may not be available to her, and it's not in the mediated settlement agreement. So accordingly, we're asking that it be deleted and not included.
All right. Mr. Hiller?
Yes, ma'am. So I think that both parties would agree that there have been a number of delays. It's obviously the mediation was almost 2 years ago. And usually when that happens, there are communication issues with the clients. So this is something I got recently from my client for whatever reason that the delay occurred. And this is an unusual asset, and this doesn't change anything substantive. And so this comes out of, I know that these come out of specific documents related to the asset. And my client is concerned because it's actually, as I understand it, an equity interest in a former employer's in the company and or building. I'm not sure exactly, but it's not even a place where it's not an ESOP or anything that we're used to dealing with, but what we call, of course, a special or unusual asset. So that's why he provided this language. And I would agree, again, I think we've got honest counsel before you. And I would agree there's nothing about this. This is not in the MSA. It's purely trying to be specific. My client's concerned that he won't get notified and something will happen to the asset. It actually is one of my nephews is in, he's in private equity, and this is apparently the type of private equity. So he was explaining to me.
Object to Mr. Hiller's nephew being,
Okay. It's not necessary.
Well, yeah, I see it. I see it on the spreadsheet, but I guess that's the only place it's reflected in the MSA as far as that.
Yes.
goes. And it divides it 50% and 50%.
That's correct.
And then
I
on
think that's all it says,
mom's, yeah, on mom's list, it has an amount, if I'm looking at that correctly.
Let me pull that. Yeah, because I have to minimize my screen a little.
As
to do
of,
that.
yeah, it's an amount as of June 28th, 2023.
That, if I may, you're right. So that's on our spreadsheet, right? Yeah,
Yes.
I'm looking at it. Yeah, exactly what you just said.
There's wife's equity.
Zealous, right?
I don't think I can add this language though, Mr. Hiller. It's,
I understand. We all try to make our clients happy. They have anxieties about things that perhaps sometimes go beyond our appreciation, and we all want to make sure our clients get the assets they're entitled to, and everyone standing before you, including Your Honor, knows there are enforcement proceedings available to us should someone not get what is available to them, what has been awarded to them. And sometimes it's a difficult situation, because all I was trying to say before, I will not refer to my nephew, except that with these types of assets, there are, with certain size private equity, they have to publish things every quarter. With the smaller private equity, they don't. And so sometimes in this particular situation, there won't be any way of his knowing, other than his wife telling his ex-wife, soon to be, telling him that, in fact, she's gotten information on it. That's all. I understand
Sure.
where you're coming from, though.
Sure.
in that regard, Your Honor, I would be remiss if I did not defend the fact that Ms. Walker has complied with every order of the court throughout this process. She is an honorable woman, and she's ordered to notify him if she receives any documents regarding to this. She's been gone for 4 years from them. There's no documents that have come her way. There were discovery disputes regarding that during the pendency of the case. Ms. Walker will, in fact, comply with this order, and Mr. Stoops will get whatever he entitled to, if, as, and when she does.
All right. Thank
Yep.
you. You can go ahead and delete those paragraphs. Thank you, Ms. Olson. Does that complete our disputed language?
It does, Your Honor.
It does, Your Honor. The only other thing is that if my client had been here, I know there are things he wanted to put on the record. It's been a long time since, and I just want to make sure it's on the record. That's all. I'm not arguing anything, but I just wanted to make sure it's on the record that since it has been so long, there's been a significant change in his financial situation. He lost his job. I don't know. I think he's got some good prospects, but he's working toward reemployment. And I had to explain to him that we have to get the MSA turned into a final decree. What he does after today, whether with or without me, is another story. He understands there are options available to him, whether they have any chance of success or not when it comes to property. I'm not commenting or saying anything on the record, but I just wanted to put that on the record that he had hoped we could change some things, and we could have if we both agreed, but we did not. There was no agreement to proceed on making any changes in the property division. That's all I want to say, or in any other financial aspect of the decree or the MSA.
Okay.
Thank you.
Well, understanding that is on the record, I think the best I can do for both of you is to get this signed. So
Yes.
do we want just my signature, or do we want this version to be signed off by each of you and your clients?
I would be happy, given that we've now had this before the court and represented to the court, that this is the agreement of the parties. I would be happy for this to be simply signed by myself and Mr. Hiller. We can do that by DocuSign. Miss Olson's about to have it ready, I think, in probably 5 to 10 minutes.
Okay. Well, as soon as it hits me, I will sign it and get it entered. I appreciate you working through this. At least, we do have my rulings on the record, so obviously it's clear what you agree or don't agree to, but what my rulings are. So we'll get that signed and entered for you as soon as it hits me.
Right. And Your Honor, if I may, just to make sure and I'm fine with what Mr. Powers just said, not having either client sign is fine with me.
Okay. Thank you very much, gentlemen. With that, and thank you for your help, Miss Olson and Miss Marnie. I will excuse you for today.
Thank you so much.
All right.